Good evening. I'm Chief Judge Gutierrez. I sit on the governing board for the Ninth Circuit Historical Society, the NJCHS, and on the board's behalf, I would like to welcome you, those of you that are present and those of you that are in the Zoom room. Welcome to this evening's program. For those of you that have not participated in one of our programs before, I just wanted to take a brief moment to speak about the Society and the work that it does. The mission of the Society is to educate about the vibrant legal history of the West and more generally about the essential role of the judiciary. The Society accomplishes its mission through its oral histories, through its journal, the Western Legal History, and through programs like this. The most recent issue of the journal is dedicated to water in the West, and it can be found on the NJCHS website. As a complement to that issue, tonight's program is part of a series of water law programs, and that the Society has been holding those programs throughout the circuit. Before this program, we've completed programs in Hawaii and Phoenix, and we have upcoming programs in San Francisco, Sacramento, and Las Vegas. You can watch the past programs and find out more information about the future programs also on the njchs.org. I'd like to introduce Robin, who will make the introductions of our panelists today, and thank you for your support of the Society.
Hi, I'm Robin Lipsky, and I have the honor and the privilege of being the Executive Director for the Ninth Circuit's Historical Society, the NJCHS. We're so thrilled to have you here with us this evening. I'm not going to take much time away because we have an amazing panel. I will just do one housekeeping matter that I have the CLE sign-in sheet here, so if any of you signed up for CLE but didn't sign in yet, please just see me after the program. We're so thrilled to have everybody here today. As Chief Judge Gutierrez mentioned, this is a program which complements our latest issue of the journal, Western Legal History, which you can find off of our website, and I commend you to check it out. Two of our three speakers this evening have written articles for that issue, and the third sits on our Western Legal History board, so you're in excellent hands this evening. I will introduce Professor SAXER, and then she will take the panel from here. So Professor SAXER is the Laure Sudreau. Did I get that right? Oh, thank you. Chair in law and has been a law professor at Pepperdine University Caruso School of Law for over 30 years. That seems impossible. Teaching first-year property, land use, and environmental law. She's co-authored the 3 books that she uses to teach these classes and has focused her scholarship on topics such as eminent domain, conflicts between local government units over commercial land use decisions that impact surrounding communities, the Religious Land Use and Institutionalized Persons Act, water law, luckily for us, and zoning conflicts with the First Amendment rights. So thank you so much, and thank you to our panel. I will just say one other thing, which is thank you so much also to the Central District of California for all of their support of the Society throughout the year. They are amazing benefactors and supporters, and we could not do what we do without them. So with that, I will then turn things over to SHELLEY.
Okay, thank you for that intro, Robin. And now it's my pleasure and honor to introduce my 2 colleagues on the panel this evening. First of all, Professor Robin Craig is the Robert C. Packard Trustee Chair in Law at USC Gould School of Law. And I've known and admired Robin for many years because of her amazing, prolific scholarship and her incredible energy. She's written so much in all things water, including the relationship to climate change, the Clean Water Act, ocean and coastal law, marine biodiversity, ecological resilience, and I'll stop. But there's more. She's written 12 books, over 100 articles that have been published in law reviews and in science journals. So I was very excited when I heard that she would be coming to USC from Utah because I had hoped to see her more often, but this is the first time that we've seen each other in the 3 years that she's been here now. So please join me in welcoming Robin Craig. Now, Professor Peter Reich has been part of the UCLA faculty since 2019, but I've known him for many years, since I started teaching at Pepperdine, because of his scholarship in environmental law, in water law, and with his PhD in modern Latin American history, he specialized in the legal history and natural resources law of Latin America and the U.S. Southwest. When I did the research for the piece that I wrote for the journal, I came across a lot of his writing in this area. So if I can't answer your questions, he can. Anyway, he also serves, as you heard, on the editorial board of the Western Legal History that published the current journal. So again, it's been several years since we've seen each other, but it's such a gift to be with you here tonight. Join me in welcoming Peter. And now I'm going to turn it over to Robin.
Okay, is this working? Good. And there we go. All right, so our theme tonight is sharing water in the West. I looked at the Colorado River for my article in here, and so I'm going to combine both that and some work I've been doing with the Navajo Nation and their need for water, which is related to the same basin. So with that, next slide. All right. Western water law is generally not associated with sharing. Next. So, infamous quote attributed to Mark Twain. I am still looking for the actual source. If anyone's ever found it, I have not found anyone who has. But it's attributed to Mark Twain. So whiskey's for drinking, water's for fighting over. And that's the traditional view of the West. And that was what was gearing up for the Colorado River as well. Next slide. So if you're not familiar with prior appropriation, just some general points. Next, it is the water law that it generally applies west of the Mississippi River, particularly to surface water. Most states in the West also use it for groundwater. California and Arizona are major exceptions to that. Next, it's based on a doctrine that your water rights derive from actual use. And the priority is first in time, first in right. Whoever takes water from a certain source first and puts it to a beneficial use, which isn't all that hard, gets the senior water right. And the senior water rights are perpetual. They last forever. And under the doctrine of prior appropriation, knowing that water is scarce in the West, if you have a senior water right, you get your full water right before anyone junior to you gets anything. It's also use it or lose it. Next, so if you don't use your water, water is incredibly valuable, so eventually you abandon it or forfeit it. Next, they are property rights, so the rights are transferable. And next, and importantly for the ecology of the West, the water can be taken out of the watershed wherever you need to use it. All right, next slide. So just an overview of the Colorado River, and this is going to get real busy real quick, but next. All right, there's the Colorado River Basin. It starts up in Wyoming and Utah next. And it starts flowing down next. All right, and so we get to the first of the two big dams, Glen Canyon Dam, which creates Lake Powell next. Obviously flows through the Grand Canyon next. Hits the second of the two major dams, creating Lake Mead. Flows through the border of Arizona and California next. And is supposed to make it to the Gulf of California and rarely does. intercepted. Whatever is left is intercepted usually by Mexico when it crosses the border. So, but that's the overview of the Colorado River. All right, next slide. So California largely drove the sharing of the Colorado River because it does not now and did not then want to. Next, 1849, we all know California Gold Rush. That's what led to California statehood. Next, in 1850, 1855, the California Supreme Court decided Irwin versus Phillips, recognizing the prior appropriation traditions that miners who were basically squatting on either territorial, state, or federal lands had developed among themselves for divvying up water. Next, 1850s and 1860s is when you start getting calls to, hey, we got this big river over there. Let's build a canal to bring it to Southern California. So this is very early in California's history that California was eyeing the canal. Why all this is important is because of the California Gold Rush, California jumped the queue on statehood. So, mostly statehood, sort of going east to west, but then you get this leap to California that's at least a couple of decades, and in some cases 50 years ahead of all of the rest of the Colorado River Basin states. Next. So 1901, George Chaffee completes the first canal, which is called the Alamo Canal. Next, it didn't last very long. It was a big flood in 1905, destroyed the canal, created the Salton Sea. Has had some long-lasting consequences. But nevertheless, the dream of the canal was, the canals were keeping on. So next, 1907, at the same time, the Supreme Court is starting to decide interstate water disputes. In Kansas versus Colorado, it says, hey, the fact that you both recognize prior appropriation might be kind of important to how we divvy up in interstate water. Next, 1911, we get the Imperial Irrigation District forming. Next, 1922, Wyoming versus Colorado. Hey, not only is prior appropriation sort of relevant to how we're going to divvy up water, interstate waters, we're actually going to apply it and divvy up the water that way. Panic ensues among the other Colorado River Basin states. Next, 1923, William Mulholland, famous for a lot of things, Owens Valley among them, says, hey, now that we're done with that, there's this big river over there we're kind of interested in. So knows how to get the job done. Next. So 1928, we get the Metropolitan Water District in LA. And next, so by 1928, we have two big water districts in California eyeing the Colorado River greedily. With the money and the technical capacity to take it all if they're so inclined, which they kind of were. Plus, this is happening against a backdrop of a Supreme Court that has just said twice, prior appropriation matters. And California's in the position of saying, hey, first in time, first in right, that could all be ours. Hence the negotiations. So that's where we get the negotiations to share the Colorado River rather than divert it all to Southern California. So next slide. There's three methods, if you're not a water law geek, to divide interstate waters. I've already mentioned one. Any battle between two states next can go directly to the U.S. Supreme Court. If the state's a sovereign, and the doctrine that the U.S. Supreme Court came up with to divide interstate waters is equitable apportionment. It is intended to be equitable. It recognizes both states as equal sovereigns. But like I said, basically the Supreme Court said we're going to consider whatever we think is relevant, but prior appropriation is one of the things they consider relevant. Next, the second way to divide up an interstate river is through an interstate compact. This is actually the way most of them have been divided up, in fact. And so with Congress's permission, states can get together and negotiate their own solution for how to divide up an interstate river. Next. Third option is because this is interstate, Congress itself can divide up a river. Congress doesn't do that very often. Arguably, it didn't think it was doing that with the Colorado, but that did play into the Colorado's history. All right, so next slide. Like I said, compacts are a big deal for the Colorado River. The U.S. constitutional provision that's important is Article 1, Section 10, Clause 3, which says no state shall, without the consent of Congress, enter into any agreement or compact with another state. The negative implication is if Congress signs off on it, compact away. And so that's what we've got next. So first in line for the Colorado River was the Colorado River Compact, which divided the river into the upper basin and the lower basin. Next. 1922, everybody joins in except Arizona, which is a holdout in a lot of this, didn't join until 1944. Basic bribe was that if you guys agree among yourselves how to do this, federal government will supply a lot of money for water infrastructure, which is expensive. The basic divide in the Colorado River Compact is on average both the upper basin and lower basin get 7.5 million acre feet per year. Acre foot, again, not a water geek, the amount of water it takes to cover an acre of land with 1 foot of water. It's a lot of water, all right? Numerous ambiguities in that compact that are not really relevant to this discussion, but someday possibly could be. All right, next slide. Next big event is that we enter into a treaty with Mexico so that Mexico is added into the equation. Mexico gives 1.5 million acre feet per year. The Colorado Compact of 1922 says if we ever get into a treaty with Mexico, you share equally, making sure Mexico gets its share. But we now have a basic operating assumption that there should be 16.5 million acre feet per year in the Colorado River. That has never been true. On the best time frame, it's more like 15 million acre feet per year. Realistically, it's more in the 12 to 14 million acre feet per year, which is why we're having some of the controversies we're having. Next. So next up, the upper basin states, which have always gotten along better than the lower basin states, got together and negotiated a compact in 1949. It's basically based on percentages because one way of reading the original compact is if there's a shortage, the upper basin states bear the brunt of that shortage. Not the only way of reading it, but they decided that percentages was a much more rational way to go. And so, again, basic federal bargain next. We got significant inflows of federal money to build the water infrastructure and the dams that the upper basin needed. Next, the real water war in the Colorado River has always been Arizona and California, and Arizona sued for inequitable apportionment, one of the longest running Supreme Court decisions or cases. It's still technically under the Supreme Court's jurisdiction. But eventually what the Supreme Court decided in Arizona versus California is that Congress had already apportioned the lower basin in the Boulder Canyon Project Act. So next slide. Next. You add all that in and you get a piece of pie that sort of looks like this. And I like this slide because that 1.5 million acre feet that's supposed to be going to Mexico is always hard to shove in the pie because there isn't actually 16.5 million acre feet. But that's where we came out through compacts. So the last little bit I want to talk about is the part of the Colorado River story that is making headlines in a recent Supreme Court decision. Next slide, which is the sovereigns that were left out of all of this, which are the many, many, many tribes that exist in the Colorado River Basin. Collectively, they have a lot of water rights. It's over 3 million acre feet that have been adjudicated. And about 500,000 acre feet more that have not. So that's a lot of water that most of the tribes have not yet seen their full allotment of. But next slide, the doctrine under which they got those water rights is the Winters Doctrine, decided about the same time the Supreme Court is deciding interstate water cases, but never connected the two. And so what the Winters case said is when the federal government sets aside a reservation of land, in the case it was for tribes, but this applies to national parks and national forests and everything else, you get enough water to fulfill the purpose of that reservation. So for a tribe, that is to have a homeland. And that is the basic standard of a Winters right. Next slide. There were some further developments about these rights. These are very special water rights as the West goes. Next. The right takes as its date of priority the date of the federal reservation. So when you're talking tribes, these tend to be very senior water rights. Very senior water rights. Next, the unexercised rights never expire. So unlike a prior appropriation right based on state law, these cannot be abandoned. They cannot be forfeited. Next. The reservation of water rights could take place before or after statehood. So whenever the tribal reservation was set aside, that's fine. Next. Federal reservations of water right can involve navigable or non-navigable waters. That was an argument because states own the beds and banks of navigable waters, and they therefore argued you couldn't have a reservation out of a navigable water. Supreme Court said, yeah, you can. That's fine. And next, either Congress or the president can reserve the water rights. So basically, it all cuts in favor of the tribes. Looking really good for tribes at this point. Next slide. How do you measure it? In Arizona versus California, the court came up with what's known as the PIA standard next, which means practically irrigable acreage. It's based on how much you could farm. The court's idea next was this would be determined once and done. We set a number and then we don't go back to this. There's some issues that are still kind of floating out there next. First, can the tribe use the water for something other than irrigation, like a casino? Modern tribes not inclined to be out there farming quite like they were. Next, can the tribe get more water for other uses? The answer is yes, but they have to go through the state water rights has been the consistent answer on that. And then next, the third issue, particularly important for the Pacific Northwest, not so much the Colorado River Basin, are treaty water rights for fisheries different. So a lot of the Pacific Northwest tribes have specific passages in their treaties that reserve their fishing rights, and that has created time immemorial rights for several of the Pacific Northwest tribes. All right, I am coming to the end, I promise. So next slide. Connecting the two issues. Why does this matter and why is Arizona the holdout state? It matters because there's a lot of water rights tied up in the tribes. If they come from the Colorado-based system themselves, they come out of the state's share. So if you're Arizona looking at that big bar that doesn't fit on the rest of the graph, there's a little bit of resistance to reifying those tribal water rights. Next slide. Which took us to the Navajo Nation case that was decided in June. And so what happened in the Navajo Nation case, Navajo Nation is one of the tribes that has not been able to get its water rights quantified. It actually was named in one of the Arizona versus California iterations, but its water rights were not quantified in that decision. It doesn't have the infrastructure. One of the papers I did was what that meant for them during COVID, and they suffered horrendously during COVID. They had infection and death rates worse than New York because there was no running water in anybody's home. So they couldn't take the basic isolation methods. So they brought a long-running suit. It took a long time to get to the Supreme Court. Basically arguing that not only do they have water rights, but the federal government has a tribal trust responsibility to actually get them water. And so the Supreme Court split it, actually did say, yes, Winters' rights are still valid. You definitely have Winters' water rights. Next, but also said, absent specific language in the treaty or in a federal statute, the federal government has no obligation to make sure you actually get wet water. So I will leave you with NARF's response. Next slide. which was kind of like you hold these in trust and yet you have no trust responsibility to do anything for them. So the Native American Rights Fund was not too happy with that decision. All right, so that's it. Thank you very much. Next slide.
Okay, thank you, Robin, for setting that up. Can we go to the next slide? Next. Okay, let's go next. So the reason I decided to write, I was invited to write an article for the journal, and I thought, what don't I know much about? So that was Pueblo rights doctrine. And so that's why I chose that topic, and I learned a lot, and again, from Peter's work as well. So we start, I think, by recognizing that the doctrine of Pueblo water rights is not conducive to the sharing of water in the West, okay? It is distinct from the rights of the Pueblo Indians in New Mexico, not to be confused with their water rights. And so I'll explain a little bit about that. But what the doctrine says is that if a municipality is established from a historical pueblo, it has the right to use all of the waters necessary to supply its inhabitants, not only current needs, but as the municipality expands, annexes other areas, Pueblo rights entitle them to seniority. And so it started off with the idea that the municipalities that began as established pueblos with Mexico and Spain, they possessed a water right that allows them to take water from the adjacent water course. Right now, California is the only state that recognizes this doctrine. So I doubt that other states are going to adopt it, and my conclusion is I think we need to look at reform in this area along with a lot of other rights. So next slide. Okay, so how is this distinguished from Pueblo Indian water rights? That is happening generally in New Mexico. And New Mexico, actually, as I'll explain later, rejected finally the Pueblo water rights doctrine, but they still deal with the Pueblo Indian rights in New Mexico. And their basis for claiming water rights, the Pueblo tribes, is that they occupied the land for centuries. And this is before Coronado arrived in 1540. And they continued to occupy the lands throughout Spanish and Mexican rule. So after the Treaty of Guadalupe Hidalgo in 1848, they actually became fee simple owners of the land that they had occupied. And the United States affirmed those rights, land ownership, in the 1924 Pueblo Lands Act. And that also recognized the water rights associated with the land occupation. And I think, yeah, so the Pueblo Indian water rights are not based on state water rights, nor are they federally reserved rights that Robin was talking about, which means that they're not subject to the Winters Doctrine. Okay, so they have this independent basis. They didn't enter into treaties with the U.S. Now, this issue came up just recently, 2020, in the 10th Circuit in a case called United States versus Abuzelman, where the U.S. Supreme Court decided one discrete legal issue. and that was whether the Pueblo's Aboriginal water rights were extinguished when the Spanish imposed their authority, even though the Spanish did not take any affirmative act. And the 10th Circuit said no. A sovereign must affirmatively act to extinguish Aboriginal water rights, and remanded the case. Again, a long case. It was originally filed in 1983, and right now it's with a magistrate judge, and they just filed a joint status report on September 15th, so it's still going. All right, so that's to distinguish Pueblo Indian rights in New Mexico from the Pueblo rights doctrine based on municipalities that were preceded by colonized Pueblos. Next slide. That's just a picture of the Jemez Valley that was involved, or that is involved in the embezzlement case, where you have multiple Pueblo tribes who are claiming rights to it. Next slide. Okay, so in California, California applies this doctrine, and it really allows for monopolizing many water rights just by a few cities and landowners that happen to be in the place of what actually was historic communal water sharing under Spanish and Mexican law. So a lot of work that Peter's done in looking back at these documents. Currently, California defines 38% of its water rights are riparian, that were originally there, and then pre-1914 appropriative water rights, and then the Pueblo rights as well. So those three categories make up 38%, and they are not subject at all right now to the authority of the State Water Resources Control Board. They only have authority over about 40% of state water rights, and the federal government has the remaining 22%. So as we see the strain of climate change and even the over-appropriation, the paper water rights that have been created, researchers have urged California legislature to clarify the authority of the State Water Board. And I think there was an LA Times article about this, that the legislature passed a Senate bill that is supposed to, I'm not sure it's gone to Newsom yet or not, to be signed, but it does say that the State Water Resources Control Board has the right to go in and start looking at these older rights and validating them and taking control. Next slide. Okay, so in this whole doctrine of Pueblo water rights, the Treaty of Guadalupe Hidalgo in 1848 is what has been guiding the development or the rejection of Pueblo water doctrine. That ended the war between Mexico and the United States, and Mexico ceded a lot of land to the U.S. government. California, Nevada, Utah, New Mexico, most of Arizona and Colorado, among some other states. And the treaty provided that Mexicans who were living in the ceded lands could choose to become American citizens and have their property rights recognized according to Mexican civil law as established. Unfortunately, the subsequent history of this treaty is one that resulted in dispossessing the Mexican people from their land through force, fraud, discriminatory practices. All right, but based on that is how we come, and let's go to the next slide. We come to have California Supreme Court developing this doctrine, beginning with the Lux v. Hagen case in 1886, where it also held that appropriative rights would be secondary in seniority to riparian rights. And so the court interpreted the laws of Mexico under the treaty to find this power of the pueblos. And so we then also see a history with the Vernon irrigation case where we recognized LA as a pueblo so that it could take all of the LA River. Now, courts in reviewing these pueblo rights, you see that New Mexico, after California, recognizes, based upon a lot of the work that was done in the California cases, recognized the doctrine of pueblo rights, distinct from the Pueblo Indian water rights. And they later rejected it. So recognized in 1958 and then 2004, they said, no, this doctrine is just inconsistent with prior appropriation. And then we get Texas, they're confronted with this, and Texas says, no, we're not going to accept. At that time, New Mexico still accepted the doctrine. Texas refused to accept it. And they also distinguish between the right to own water and the right to use it, which is key, and I'll talk about that in just a moment. Next slide. Okay, so I'm not going to take the time to go through all of the various reasoning, but it's been disputed as to whether this was an appropriate interpretation of Mexican and Spanish law, which was more based on communal sharing. And instead, we have these priority of rights. Okay, next slide. So this is what I think is a key question, and Robin kind of ended her talk saying that these are property rights. And I question, and others are questioning, is this a property right, or is it just a usufructuary right, as we say it is, a right to use? And the Texas court did say there's no ownership when it said, no, we're going to reject the Pueblo rights doctrine. He said there's no ownership in the corpus of the water, but if you acquire it for beneficial use, then yes, you can have a right to use it. And California was interesting in the Vernon irrigation case, recognizing LA as Pueblo. One of the things that was said in the majority opinion recognizing this is our practice is to reduce everything to private ownership from which a profit can be made. And of course, the more essential it is to the members of the community, the more profit can be made by it. The rule of the Pueblo was almost the reverse of this. So far as communal ownership would answer the purposes of the community, it was preferred. And so in conclusion, and next slide, I think we need to look at reform in California, and I think we need to say that expanded use of the regulation of water that we may see coming is not going to violate either the state or the federal constitution as a taking of property. And so that, I think, has to be made clear in California, because I don't think the Constitution is exactly clear as to how we do treat water. And I think I'm going to stop there because I don't want to take up too much time. Okay. Thank you.
Thank you both for all those insights. This is my title slide. So this is a little bit of a counter story to the rights concept that both Robin and Shelley have. 3 years before the Lux case that Shelley mentioned, in 1883, there was a case in Orange County where equitable water allocation as opposed to riparian rights being superior over prior appropriation was proposed by the court. And so this view in Orange County is going to be echoed in a number of cases, and then also in the administrative system that the Orange County Water District uses. So we're going to focus, move from sort of the Southwest and the Colorado Basin, then to California with Pueblo rights and New Mexico and Texas to sort of a micro study of Orange County. And this talk is really, it's a summary of an article I'm having come out in the Orange County Lawyer, which is the local professional journal. And I have some rare photos that you'll see from the Anaheim Public Library and the Santa Ana Public Library. And I also used the trial transcript from UC Irvine's regional history collection. So next slide, please. So beginning with geography, which I think when we talk about water, everyone has to understand the sort of geographical system that we're dealing with. Geographic and climatic context played an important role in water disputes and their resolution in Orange County. Most of the county is semi-arid. Rainfall comes largely during the winter when traditionally less water was used. Now with more and more urbanization, that's less of an issue, but a lot of these cases were sort of based sort of on the idea that there wasn't enough water at the time that it was available. But this variability in rainfall is offset by the fact that there's an underground basin which underlies about 40% of the county. And originally it was accessed by wells, and now today by a very complex storage and distribution system of reservoirs, dams, and channels. If any of you ever have a chance to go on the Orange County Water District's tour, it's a fantastic tour. You get to see the inflatable dam, you see the Prado Dam, you get to see all kinds of pieces of infrastructure, and they give you, it's an all day, but I strongly recommend it. The county's replenishment capacity has responded to these local shortages as well as mitigated conflicts between the lower and the upper Santa Ana River basins. That is, in other words, Orange County as opposed to Riverside and San Bernardino County. So you can see here on the map down at the bottom, you've got Orange County, but the Santa Ana River system, which is the major river system in the area, and there's some other smaller systems, but it flows southward, starts on the slopes of Mount San Gorgonio, which I actually hiked when I was 9 and 10 years old. And I didn't realize at the time, there's a place called Slushy Meadows on the slopes of Mount San Gorgonio, and that's the headwaters of the Santa Ana River. Then it goes through San Bernardino County, into Riverside County, and down into Orange County. And so I didn't realize as a 9 or 10-year-old that I'd be, working on this in some kind of professional capacity, right? I was just, anxious to get to the top of the mountain and back and eat my beef jerky and be home. Next slide, please. As Professor SAXER SHELLEY pointed out, during the Hispanic period, landowners shared water during times of shortage, and that's this part of this historical discussion about the myth of the Pueblo water right. When the U.S. annexed the Southwest, many decisions in California, such as Lux and the larger region, emphasized absolute rights, either by riparians, as in the Lux case, or as Robin discussed, prior appropriation in other states and other areas. The Orange County model, very interestingly, became more cooperative from a very early point. And so there's a case 3 years before Lux called Anaheim Water Company versus Semi-Tropic Water Company. And that's where an upstream riparian successor to the Yorba land grant drew water that supplied a ditch that was being used by the German immigrant colony of Anaheim. And the Anaheim claimed an easement from the Yorba family. And you can see in the picture here, this is an irrigation ditch of the type. We don't know from the Anaheim Public Library exactly which ditch it is, but it's of the type that Anaheim Water Company was using. And if you ever read the novel by Susan Sontag about Orange County called In America, a great novel. It's all about the Polish actress who came and started a colony in Orange County in the 1870s. They talk about the Anaheim Water Company because it was the major institution in the colony at that time. Anaheim Water argued that they had always had the right to have their ditches filled. They also drew from wells, which accessed the local groundwater. In 1877, a drought caused the defendant in the case, Semi-Tropic Water Company, to take more than its usual share, and that had an effect on the colony's trees and vines and crops. And there's all kinds of documentation of this in the trial transcript at UC Irvine about how people wrote out to sort of their land holdings, and they found the trees were dying, the vines were dying, and of course, Anaheim was very largely dependent on vineyards, and so this was very important economically. The trial court in the case ruled that Anaheim was entitled to a full ditch at all times, at all seasons, to its utmost capacity. So they're flying completely in the face of the idea of riparian rights as opposed to appropriation. The California Supreme Court then, sitting at that time both in San Francisco and Los Angeles, reversed in favor of Semi-Tropic, which was the successor to the Yorba Grant, and they decided based on riparian rights. But in the opinion, at the end of the opinion, they said, look, in view, they didn't say look, they said in view of the value of the water in dispute, it's advisable for the parties to divide the flow on an equitable basis, right? Prefiguring equitable apportionment, right? Which is exactly what the parties did. They divided the water 50-50 at Bedrock Crossing. Next slide, please. So you have, here's another early picture, 1890, of Bedrock Crossing near the border of Orange County and Riverside County. And this approach of promoting equitable sharing set the tone for later Orange County and Santa Ana River Basin litigation. So in subsequent cases, there was one in 1906, Stoner versus Zucker, which affected both Orange County and Riverside. A riparian owner gave a license to an appropriator to build a canal over the riparian owner's land, and thus the appropriator relied on labor and time that he put into building this canal, and so the riparian owner could not withdraw that license. So it was another limitation on riparian rights coming out essentially of Orange County. In that case, the trial court decided in favor of the canal builder, the appropriator, licensee, and the Supreme Court, California Supreme Court, affirmed. Next slide, please. So this moves us into the upper versus lower Santa Ana River Basin conflicts and issues. So in the early part of the 20th century, up through the 1930s, you see increasing urbanization and replacement of agriculture with cities and suburbs. That leads to further demands on the water supply in the Orange County area and beyond. Upstream shareholders, which included, let's go back to the map. Can we just go back to the map for a minute? Great. Okay, you see the upstream users in Riverside and San Bernardino County included landowners, cities like Redlands and Colton, the city of Riverside, city of San Bernardino. They began to use a technique called water spreading, where in the alluvial fans down in sort of the mouths of canyons in the San Bernardino and other mountain ranges, stormwater was captured and forced to percolate at that point, rather than running down the arroyos, the stream beds into Orange County. And so spreading became this enormous legal issue for the stakeholders in that period. And so let's go back to the upper versus lower basin slide. Right, great. And so in 1932, the Irvine Company, major landholder in Orange County, sued Riverside, San Bernardino, Redlands, and some landowners based on the idea that spreading was taking water to which Irvine Company was entitled both as a riparian and as an appropriator. In other words, satisfying both parts of Lux versus Hagen, and that the spreading actually prevented well replenishment. The suit was settled in 1942 with a stipulated judgment which limited spreading under the condition that there would be sufficient downstream flow. In 1951, Orange County, through its water district, initiated another lawsuit against the four major upstream cities. And I actually have there's a typo there, the case, OCWD versus Riverside should say 1957. The suit started in 1951. The case came down from the Court of Appeal in 1957. And they argued, the Orange County Water District argued that Riverside and the other cities were attempting to, by prescriptive right, take water to which, again, they were not entitled because Orange County Water District was both a riparian and a prior appropriator. And the decision from the California Court of Appeal in 1957 limited the upstream cities to prescriptive rights based on the average amount of water they'd taken in the 5 years before the lawsuit. And so judicial allocation in this region is really flying in the face of this traditional doctrine of rights being absolute as per Lux and other cases. And then you have a series of stipulated judgments, 1969, 2006. There were several of these where the local courts or simply water districts would agree and go into court and decide on how much water every district was going to get. So we have this tradition both in cases and as well as parties coming together with stipulated judgments, filing these or asking courts to sign off on them, saying that rights were not what was important. What's important was this equitable sort of equitable sharing. It's a very complicated story. There's a lot of detail in it. Orange County Water District has very nice history, which you can get online. It goes through all of this, and as well as many of the stipulated judgments actually available online. Next slide, please. But I want to move from the legal solutions to the administrative solutions. So in addition to this history of judicial decisions, Orange County Water Management has taken this administrative form. In 1953, the Orange County Water District consulted with committees of local farmers and cities and decided to impose a pump tax to pay for outside replenishment and to disincentivize excess withdrawals. And so every surface owner would pay this pump tax based on the correlative rights doctrine. So correlative rights doctrine is very sort of in the weeds water law doctrine, comes out of Katz versus Walkinshaw, which is a 1903 case, basically says that surface owners have a proportional right to the common water pool below. And it's parallel to doctrines which are used in oil and gas and other resource cases. So this pump tax disincentivized excess use. In 1969, the district imposed what they called the basin production percentage, and they figured out an amount that could be pumped yearly based on what was available, and if you exceeded that amount every year, you paid more. It wasn't a water rights doctrine because they weren't taking away your right. It was really a tax on use. So this fits back into this discussion of usufructory rights. What's interesting about this system is it's basically worked. Compliance has been very high, according to people who've analyzed it. Most recent analysis came out from a Japanese scholar in 2019 who wrote an article about it. The critique is that agricultural users are favored, that agricultural users get a slightly better rate under the basin production percentage. But what's interesting here is that the incentive system, this administrative incentive system, has been adopted in other places, particularly California counties. Alameda County has adopted a version. Santa Clara County's adopted a version. The Stockton Water District, Stockton and East Joaquin Water District has adopted a version, and the Mojave Water District has adopted a version. So it's this idea of sort of not even thinking about or talking about rights at all, just thinking about what's available and then setting a percentage and then sort of dividing it up by the Katz versus Walkinshaw correlative rights formula, but still saying if you use more than this amount, you'll pay more. And the excess amount that you have to pay does in fact disincentivize use. So in conclusion, Orange County's rejection of the formalistic water rights idea echoes the concept in jurisprudence of legal realism, right? Oliver Wendell Holmes' 1881 statement, law should reflect the felt necessities of the time. Law should reflect institutions of public policy. It should not be based on rigid doctrinal categories that are imposed from above. So the 1880s was not just a period when absolute rights were in vogue, but it was the beginning of the sustainability concept that is forming our ideas about how water should be allocated today. So thank you.
Okay, so are there any comments, questions from the audience? Yes.
This question is so on the very last point about the Trump tax disincentivizing excess use. Another way to say that is encourages conservation. So we could do that with any kind of water, right? I mean, when I get my LADWP bill, I'm amazed at how low it is. Why? You know, there's nothing encouraging me to turn off the faucet. So is that being done anywhere? Tax as a way to encourage conservation?
Yeah, I'll punt on that a little bit. I know some water districts do it. Exactly, and I know we have some people from the MWD here, and I know that it's used in some context. It certainly is used in Alameda and Santa Clara counties. They adopted a version of the San Diego system. I can't speak for other districts. It's not something, but I think it. I just finished a cooperative project a couple of years ago with a hydrologist from Jordan. And we're looking at the Israel-Jordan water treaty. And Jordan actually does use an incentive system. And there's a country highly water, lots of water shortage. And what's interesting is you talk about conservation. And people in Southern California, complain, if they can't water their lawns. But there are many parts of the world where people the whole idea of having a lawn at all is ridiculous. Right? And so we talk about other types of technology, desal, whatever, but we haven't done everything we can do to conserve, whether it's through percentage reduction or otherwise.
Yes, let me go to the back first. Yes.
I was wondering about detailing I was if you are aware of one practice about that, what
Okay, so the question is about desalination and what's happening on that front. I have not looked at that. I think when I've looked at it, it's been that the cost is still too high for what we're currently charging for water.
Go ahead.
I was going to say there's been a couple of proposals recently. One of them was approved, one of them was disapproved, and it's on the basis of cost impact versus extent of need is the usual calculation. So,
well, one of my former students who now works for Toxic Substances Control, Colin Kelly, was formerly counsel for Orange County Coastkeeper, and they basically litigated against the attempted deny, got the permit for the Huntington Beach desal plant denied. And it was denied, and we watched the hearings, denied because there were already sufficient sources of water in the area that were actually cheaper. And so of all the places you could propose a desal plant, Orange County was absolutely the worst. Plus the attorneys wrote a proposed judgment on the stationery of the Coastal Commission that irritated the Coastal Commission. So they made a number of lawyer mistakes. So I would just go back to this idea that, desal maybe is something that we could have in our quiver, but let's do everything else first before we go to such an expensive and polluting form of water management.
And much cheaper is something Orange County has already did and Los Angeles is in the process of doing, which is water reuse. Rather than sending it out to the ocean, just treat it to drinking water standards.
And yes, you gentlemen in the fourth row.
Considering sigma and basins that are already either overdrafted or just barely, how does reserved rights of the Winners Doctrine play in where the tribal areas are not developed? Water's already being used for 100 years. Do you see any thought on that?
So the question is, given sigma and given the fact that Californians have already overpumped many places in California, how does the tribal water rights doctrine kick in there? Interesting, because California is the home of the most important case on groundwater and tribes, which is the Agua Caliente Band of Indians tribe case. It's actually the first case that says winters' rights apply to groundwater. So this is kind of a new concept in the tribal water rights to begin with. But it doesn't say that it has to be exclusively groundwater. And in fact, the Agua Caliente Band had to argue that there wasn't sufficient surface water to satisfy their reserved rights to get to that point. So the general process when you're getting these reserved water rights, and there aren't that many in California to begin with, because through some political shenanigans and otherwise, California doesn't have nearly as many federal tribal water rights as other states. There's not as many federally designated tribes in California as there probably should be. But the process would still be to look to surface water first. And when a tribe can satisfy its winter rights from surface water, that's generally where it will come from. So to even get to the question of groundwater, you're going to have to be looking at there is nothing else. Someday we will get to the case where all water in the area has been destroyed or otherwise used up, and we might see the first damages case on this, but we're still in the settlement getting them quantified in the first place for the tribes.
Question?
Yeah, a couple of quick questions. One is, when you talked about all the state rights of the Colorado River or the surface water, is there anything in the, not being an attorney, so just being a water person, but is there anything in the law that talks about in combination with surface water, the groundwater for these states? So that's the point.
Okay, that's a good question for Robin, but talking about the Colorado River Compact, and does it include both surface and ground, and how is that handled?
Excellent question. Basically, no, it doesn't include groundwater, doesn't include tributaries either. That's one of the parts of Arizona versus California that Arizona won. And so it is part of the reason why the Colorado River is in trouble, is because if you think about it, we divided up the main stem without including the tributaries or the groundwater that's feeding it in. So everybody's free to deplete everything that's supposed to be feeding the main stem, free of the law of the river, basically. So yeah, it's a mess.
And the other part is, what happens to new water? I just read an article recently, still in the planning, but Arizona is looking at going to Gulf of Mexico and getting desal water. And that's about a 200-mile stretch. But it is on the books right now in terms of planning stage and funding and so forth. So if they get that water, whatever amount it is, what happens to the water that they are not using anymore?
I don't think Arizona would tell you they won't not be using all the water they've all been using.
It will offset that water.
That's not what Arizona will tell you. No, will not offset. So, but a couple ways into that, because Utah has this problem too. Part of the reason for going to a compact on the Colorado River is you can't lose that anymore. So even if you brought in all sorts of new water, it wouldn't change Arizona's share of the Colorado River. It's just that share isn't big enough for how much water Arizona wants to be using. The Gulf of Mexico project or proposal is astounding and ridiculous in the same breath. Water is heavy. Transporting it any distance, not to mention the cost of desalinating it in the first place, is going to make that project incredibly expensive. I mean, people can't even get the economics of bringing fresh water down from the Columbia River to work. So I strongly suspect it's not going to happen. But if it did, the usual rule is they who make the new water get the new water. So, that's an incredibly, like I said, desal is expensive enough if it's right there and you just have to transport it a couple of miles, but to transport it 200 is really expensive.
So I'm going to interrupt because I know we could sit and listen to these fabulous people speak all evening, and I wish we had all evening to do that, but unfortunately we don't. So perhaps you will join me in thanking them for being here. And this program was recorded, so if you have friends that you know would have been interested in seeing it but weren't here to see it, it'll be posted on our website in about a week. So we hope that you will share it broadly, as well as the amazing issue of Western legal history that these authors have contributed already. So thank you all so much for being here. I know the CSOs would also like to get home, so although you might want to stay and chat, I'm afraid I can't really allow you to do that. So I hope we will in fact see you again soon, though. Thank you so much for being here.